Today, we're going to dive into a real-life showdown between a homeowner and his HOA board. And this wasn't just some small neighborhood squabble. Oh no. This thing went all the way to a legal hearing, and the verdict? Well, it reveals a whole lot about where the real power lies in a homeowners association. It really all boils down to a question I'm sure a lot of you homeowners out there have asked at some point. If you have a serious proposal, a change you want to make, can your HOA board just refuse to put it on the agenda? Can they just ignore you? That's exactly what we're going to get into.
All right, so every good story needs its characters. Let's meet the key players here and figure out what the core of their disagreement really was. So on one side, we've got our homeowner, Jason West, and on the other, the board of the Desert Sage Two HOA, right in Scottsdale, Arizona. Now, the whole conflict got started when Mr. West submitted a proposal for a new bylaw. He demanded that the board add it to the agenda for the big annual meeting. The board said no, and well, that refusal is what kicked this whole thing into high gear.
Now, these things rarely just pop up out of thin air. And the court documents, they show there was a pretty contentious history here. I mean, look at this timeline. Mr. West was actually on the board himself at one point. He'd even successfully passed a bylaw amendment a couple of years earlier. But, and this is a big but, a judge in a totally separate case had already called him out for his obstructionist tactics. So yeah, it's pretty safe to say there was some bad blood long before this particular fight.
So what was this proposal that was so controversial? What was in this bylaw that the board refused to even let the community vote on it?
Okay, so here's the exact text that Mr. West submitted. It's a little dense with the legalese, right? But let's just pull out the key phrases here. Paid claim, banned from serving for 5 years, and then the real kicker. This amendment is retroactive.
So let's put that in simple terms. What he was saying is if a board member's actions ever led to the HOA or its insurance company having to pay out money, like for legal fees or something, that person would be banned from serving on the board for 5 whole years. And because he made it retroactive, it could have potentially targeted some of the current board members based on past disputes. You can see why they might not have liked that.
So the board flatly refused. They were not putting this on the annual meeting agenda. So what did Mr. West do? Well, he felt he had only one option. He filed a formal petition. And that move escalated this whole thing into an official hearing in front of an administrative law judge. And this right here, this is the heart of the legal fight. On one side, you have Mr. West's argument. He's saying, look, Arizona state law and our own HOA's bylaw 1.5 force you to put my proposal to a vote. But on the other side, the HOA is saying, nuh-uh, those rules don't force us to do anything. In fact, a different rule, bylaw 2.2, gives you another way to do this yourself.
And this was the HOA's trump card, bylaw 2.2. It's what's called a special meeting clause. And this rule explicitly gives homeowners the power to call their own meeting for their own reasons, completely bypassing the board's agenda. The only catch, they have to get written support from 25% of the voting members.
So you've got both sides presenting their interpretations of the rules. It all comes down to the judge's final binding decision. Who was right? Who really holds the power here? The judge's approach was incredibly straightforward. They didn't get bogged down in emails or he said, she said stories about past arguments. Nope, they focused on only 2 things, the actual Arizona state law and the HOA's own governing documents. That's it. And after reading through those documents, the judge came to a pretty startling conclusion. The number of times that the rules required the board to add a member's proposal to their agenda was, well, take a look. 0. A big fat 0. There was absolutely nothing in the language of the law or the bylaws that created that obligation. So the final verdict was crystal clear. Petition denied. The judge sided completely with the HOA. They ruled that the board was well within its rights to reject Mr. West's agenda item because they simply hadn't broken any written rule. So how did the judge get there? It was a really simple, logical 3-step process. First, read the state law. Found nothing in there requiring the board to accept an item. Second, read the HOA's own bylaws. Sure, bylaw 1.5 allows for amendments, but it never says the board has to be the one to propose them. And third, and this is the knockout punch, they identified that bylaw 2.2, that special meeting rule, gave the homeowner a perfectly clear alternative path that he was aware of, but just chose not to use. Okay, so that's one story from Scottsdale, but what can we all learn from this? What are the big takeaways for anyone who either lives in an HOA or, heck, serves on an HOA board?
All right, let's break it down. Here are the key lessons. First off, as a general rule, the board controls the agenda for the meetings it calls. Second, the written rules, your state laws and your community bylaws, they are king. And what they don't say is often just as important as what they do. Third, homeowners, you aren't powerless. You often have very specific powers, like calling a special meeting that let you bypass the board entirely. And finally, this whole case proves that knowing your community documents inside and out is absolutely crucial, because having that alternative path was the single deciding factor in this legal fight.
Which really leaves us with one final big question to think about. When it all comes down to it, who's really running your neighborhood? Is it the people who happen to be sitting on the board right now? Or is it the words written down in the bylaws? I think this case gives a pretty clear answer to that.